Right, so Brexit legal update. What I aim to do in the next sort of 15-20 minutes is to give an update. We last met, some of us, sort of 6 months ago, if you've been joining our rolling roadshow, as we seek to unpack what's going on. So in the last 6 months, some of the more recent developments relating to the legal developments of all of this. And I'll be taking you to Westminster, to Cardiff Bay, and also to Luxembourg, amongst other places. And considering some of the legislative and judicial developments that we've seen today, amongst other things. And so what I want to do is pick up on Rachel's, where we are with the withdrawal agreement, and what this means about, well, what happens to it next, potentially. What happens to it here in the UK? What needs to be done? What are the alternatives that face Parliament at this time? And those alternatives are possibly different now than they were 20 minutes ago. So where are we with the withdrawal agreement? And depending on what we see, throwing from that, what does that mean for that piece of law that keen watchers will have been looking at, that EU Withdrawal Act, the one that we were so concerned about what it was going to do to existing devolved competences, the thing that is, once we are no longer a member of the European Union, turns off the source of EU law into the national legal order, but will continue to give that law some force. So rather than it all just sort of coming to a cliff edge internally, that EU law will roll forward as UK law. So that Withdrawal Act. So we'll have a little look about what all of this might mean for that Act, because these things have got to work together somehow. And we will then pick up and see that Act itself, the 2018 Withdrawal Act, although certain things will kick in perhaps on the 29th of March 2019. Some things might need to be delayed until a future time, depending on what happens next. There are already actions, there are already measures being adopted under that Act, and we'll just say a little something about those and what they mean for Wales and what they mean for devolved legal powers. The idea of common framework, so the different parts of the UK working together to create common legislative responses in areas that were previously handled by EU law, will be addressed, and then we'll have a little something about the law derived from the European Union. Sadly, no longer with us. The piece, well, no, not necessarily sadly. No, I can see there's different views there. That this, that it served a purpose, and we'll have a little look at what it was and what purpose it served and where it's got us. And we'll have a little look at some of the things that have been taking place within that sort of that sphere of shared governance, things that are going to be done in common across the UK, in a range of different policy areas. And then, bang, Whiteman, Advocate General's opinion today, that is, together with the perhaps Dominic Grieve's amendment that we've just had a vote on, these two things together might be quite significant in terms of what Parliament might be able to do should it wish to stop a no-deal situation. Okay. So, what we know is with the withdrawal agreement, yes, it needs to be all signed off and approved in Brussels, but also domestically, we need it signing off and approving. And there's a provision that was put into the Withdrawal Act that set out how this was to be done, and that there would be a meaningful vote. Parliament would get to have a meaningful vote. Now, there is a certain amount of doubt just how meaningful this vote is. But we have a provision in the 2018 Act, Section 13, that talks about approving the withdrawal agreement. That parliamentary approval, we need, the ratification has to come from a vote in the House of Commons and from the House of Lords. Excuse me. Now, withdrawal agreement ratified, and it's both of those parts. It's the withdrawal agreement, the terms on which we are separating, and also the political declaration on the future framework. They've both got to be approved. There's got to be a vote in favour in Commons and a motion in the House of Lords, and also, even when we get all of that, another Act of Parliament as well. And then there's further confirmation needs to be done under the CRAG, the Constitution Reform Act as well. So there's quite a lot to get through. But in terms of where we are with that meaningful vote, 5 days debate scheduled to start today. Obviously, things were slightly delayed by the certain contempt action that came today, and which we know now that the government has been found in contempt, and that the legal advice that it wasn't releasing is going to be released tomorrow. What we've also seen is that there's been an amendment that's been put forward, so this business of the House motion, setting out how are we going to deal with this debate. So we're going to have 5 days of negotiation and then the vote next week. The vote next week, we know, the motion can be amended. And there's some contestation around all of that, because if it's amended and if it's voted through with certain amendments, then that might look like the approval could be conditional. It might be sort of open to debate and discuss whether or not there actually has been an approval given, depending on what those amendments might look like. So we've got that going on. What we've also got going on is if there is a situation where Parliament doesn't give its approval to the motion, then the government has to come back at the start of January and explain what it's going to do. And at that point, the Parliament has another say. But as things stand, it's a so-called a neutral motion, so it doesn't go anywhere and can't do anything. The Grieve amendment today was that is amendable. That can be amended. So whatever motion is put forward by the government, it can be amended by Parliament. So what we might see then is that's the opportunity is then therefore an amendment. So it's deal or no deal. We open up the possibility of rejecting a no-deal situation. Those options then start coming in. So the Dominic Grieve Amendment has been accepted. So, if we do get to the point, did that make any sense at all? As much as anything does. All right. It's not been a great night for the government, okay? If they could lose it, they've lost it. All right. And yes, options are now there politically and legally. We're moving in a direction that things are sort of slipping away in some ways, perhaps. However, we may very well still be leaving absolutely without a deal on the 29th of March, as nothing is certain about any of this. So if we get to the stage where there is no approval for the withdrawal agreement in Parliament, whether first time round, whether second time around, and there's nothing to say that we can't come back and have another go with another attempt with another motion. But if there is no approval, then in the absence of anything else, that's it. 29th of March, we leave. And we leave without a transition period, because that transition period is part of the deal. And if there is no deal, there is no transition. So that's it. If there is continuation of EU law, that's because that withdrawal agreement withdrawal act, our withdrawal act from earlier this year, says we're going to try and keep things as stable as possible by rolling over this law. But we're not doing it because of any sort of transition period we've agreed to, is that we're putting it in place and just trying to wind it down that way. So, no transition period. So the elements of the Withdrawal Act that talk about the status of EU law and what significance it has for national law, they will kick in. The European Communities Act that gives the EU law its force will be turned off on the 29th of March. So the repeal of that, EU law converted into this retained EU law, and we know that it will create certain powers for ministers, both devolved level, but also significant UK ministers, to take actions to correct where necessary that law, to make it work now that we are no longer members. And significantly, of course, there were those concerns in particular that came about the powers could be used to sort of work within devolved areas of competence that could potentially be seen to sort of be pulling back or re-centralising devolved powers. And that ability under the Withdrawal Act to sort of freeze particular areas of devolved competence ahead of the creation of new common frameworks, where the EU law has done the work in the past to keep things together, to give it sort of coherence to the legal order in the UK, that if you take that away, the potential there for divergence that might emerge, so that the freezing and then later the common framework. So that's where we'd be 29th of March without the withdrawal agreement being approved. But if it is approved, and if we do say yes to this deal, then we will need a new piece of legislation. We've got the withdrawal agreement motion, that if that's approved, we will then need an Act of Parliament, the withdrawal agreement bill. There has been a white paper on this back from the summertime, and it envisages that it will require legislative consent because this will be operating across areas of devolved competence, and so it will come to the Welsh Assembly to give its consent to the agreement, to the withdrawal agreement bill. There'll be some interesting questions to be asked about how does that bill relate to the Withdrawal Act, and there's certain things that are going to have to be maybe suspended. If we are continuing a period of transition, what do we do for those 2 years with all the EU law that's coming in? How does it come in? Do we not turn off the European Communities Act? I mean, turning off, repealing the ECA is sort of quite a powerful political statement to be making, and that's going to be a tricky one to try and sort of manoeuvre. But it's somehow we're going to have to, if we're staying in that transition period for that length of time, find a way of bringing it in one way or the other. So the Withdrawal Act will need amending. Or certain things will have to be done to it. Certain things will have to be suspended or delayed. And the effect will need saving if it isn't, in fact, we don't sort of pause the repeal of the European Communities Act. So, wherever we are, whatever's going to happen, whether or not there is the eventual agreement of the agreement or not, there is already work taking place under the Withdrawal Act to ready the ship, to get things in place, to get things prepared for when they may eventually be needed, assuming at some point we do depart. And so preparing the statute book for that point. And the powers now being used under the Withdrawal Act, powers used both by devolved ministers, introducing secondary instruments, secondary legislation to make necessary amendments to the law in their field. So they're not operative yet, but they will kick in at a later time. And equally, measures now being introduced by UK ministers in areas of devolved competence. Now, if you remember back, there was quite a lot of concern around what the original draft of the Withdrawal Act proposed to do in relation to areas of devolved competence where they overlap with EU competences. And the idea was initially that basically everything was going to be sort of frozen and those powers were going to be essentially relinquished until such a point as new approaches and a decision could be made whether or not these could be released back to Scotland, to Wales, to Northern Ireland, that they could be used and there would be they wouldn't be sort of damaging to have differences in the different legal regimes in those particular areas. The Withdrawal Act, as it stands, as it was adopted, has a provision, Section 12, which does provide for a freezing of devolved competence. The use of ministerial regulations, UK ministerial regulations, to basically to freeze areas of law ahead of then adopting common rules, where they may be deemed necessary. So that is one possibility that we might be seeing. What we'll see is we haven't seen that freezing taking place. It hasn't been seen to be necessary to do that freezing in areas. Okay. But what we do have is an agreement, an intergovernmental agreement, that sets out certain sort of protections and guarantees for devolved competence should we see that happen. Now, When the Withdrawal Act was originally proposed, as we said, it was looking like it was going to be a lot more damaging towards devolution. And one of the things we saw the Welsh Assembly and Welsh Government lead on was the adoption of continuity legislation. And we saw Scotland also adopted its own continuity legislation, but an attempt to try and demarcate and sort of protect an area of competence. Now, the Welsh legislation, the law derived from the European Union Act, was passed, is on the statute books, was given royal assent. But there was an agreement made back in April that Wales didn't need this legislation, that the protective force that it was supposed to have, that there were other means by which that protection was going to be sought. And an intergovernmental agreement was reached between the UK government and the Welsh government that, as part of that intergovernmental agreement to set aside that we would no longer need this piece of law, so the Welsh government agreed to repeal it, or to recommend its repeal. And there were provisions in the Act itself for the ministers to repeal it. And it has now been repealed. It's now no longer on the books. It was repealed a couple of weeks ago, and there has been some consternation about this from some quarters, saying, well, why don't we wait? Why didn't we wait until we heard from the Supreme Court? Because the Scottish legislation has gone before the Supreme Court, has been tested, its validity is being tested at the moment before the Supreme Court, whether this is incompetence, whether this is something that Scotland could do. The Welsh legislation didn't go. That was part of the intergovernmental agreement, that because the Welsh government said they were going to repeal it, it didn't get sent to the Supreme Court. So, as I said, why don't we just wait and find out what's happening with the Scottish legislation, because then we can keep our own. From the Welsh Government perspective, that piece of legislation has served its purpose. It gave the Welsh Government leverage. It managed to get on the back of that agreement, the intergovernmental agreement with the UK government, which it sees as giving it a broader set of political protections. An expansion in sort of the Sewell Convention, spreading the Sewell Convention that was applying just to the adoption of primary legislation, but now expanding that Sewell Convention, that requirement of consent, that they will come for consent, in the area of statutory instruments, secondary legislation as well. And so it's been seen to be a more preferable set of protections. And after all, it was part of the deal they'd entered into. Now, what we've seen is a reporting very recently, the UK government reporting on how they're using that freezing power. And the report, the first 3 months, have said, we don't need to use it. Officials are working effectively together. We haven't needed to use the freezing power under Section 12. However, that doesn't mean that there aren't common frameworks, that there aren't common frameworks being created one way or another, that there isn't some working together to create UK-wide responses where they are required to fill the gaps that the EU law would have filled. Mark Drakeford has said that, I picked this up recently, that there will be common frameworks coming in the field of fisheries management and support, animal health and welfare, hazardous substances planning and nutrition, that these are expected to be coming before the JMC this month. So I think we're expected to see these being sort of, rather than in primary legislation, these look like they're more likely, I'm waiting to see if I get a nod or not, but more in sort of secondary legislation. And he said they will then go to sort of stakeholders for them to sort of feed in. And so we'll see common frameworks coming that way, but also just sort of working together when we see sort of primary legislation being adopted, the Brexit-related primary legislation that is sort of filling the policy gaps that EU policies would have filled, that again, they could be seen as a species of common framework, where we're setting a UK-wide framework that may give more or less space to the devolved administrations, to the devolved legislatures to fill in that space. And we see things like the agriculture, the funding, the agriculture support bill there, that Wales has got its own schedule written into the broader agriculture bill. Okay. Now, meanwhile, this is where I will take us finally, I will take us to Luxembourg, the Whiteman case. And this is a reference, a case that's come from a UK court, a Scottish court, that has been brought by a number of Scottish parliamentarians, both MSPs, MEPs, and members of Parliament. And they have brought a judicial review action to find, essentially, they want to have the question answered, can Article 50 be revoked unilaterally? And a question has been asked from the Scottish courts to the Court of Justice. And it's being asked, and it's being answered faster than we've ever seen the Court of Justice work before. I mean, it was sent, I'm just trying to, 3 weeks or 4 weeks ago, and we've had the Advocate General's opinion today. Now, the Advocate General's opinion is persuasive on the course. It isn't a court. It is not the final ruling of the court. But it is an opportunity. We see Advocate General's opinion. They assist the court in coming to its final judgment. So it's not necessarily the case that the court will go in the same direction as the Advocate General. We often see it do. It will do that. But we need to wait and see what it does rule. We're expecting to see it rule before Christmas on the basis of how quickly things have been moving here. Also, it needs to act quite quickly if it's going to make any sense to hear from it at all. Against our own timescale. So the Advocate General's opinion today, can the UK unilaterally revoke its notification under Article 50? And he said, yes. In principle, yes. You have to comply with your national constitutional requirements. And there's an assumption in that because we needed an act of Parliament to send the withdrawal notice in the first place, we'll need one to bring it back, but that's our constitutional requirement, so that's for us to determine. It has to be formally notified to the European Council. It has to be done in good faith and in the spirit of sincere cooperation. It can't be used to delay a process that we might try and achieve by doing this otherwise. But what's quite clear is it doesn't need the approval of all the other member states to say, yes, you can revoke your notification, as long as it is done before that withdrawal agreement is finalised. Okay. I'm not going to check Twitter again, because there'll be something else. So, okay, we will leave it there. Thank you.